is Jay Devine, and I'm Associate Dean in Carnegie Mellon's Dietrich College of Humanities and Social Sciences. And more to the point for today's event, I'm Secretary of Carnegie Mellon's Phi Beta Kappa chapter and the university's pre-law advisor. A few housekeeping details. For any attorneys in the audience who are here in the hope of earning some continuing legal education credit, there's a sign-in sheet in the entrance to the lecture hall where we ask you to sign in and include your license number and your email address. And there's also an evaluation form that we ask you to fill out and leave behind before you leave. There's also on the other side of the entrance a brochure for Professor Rabban's latest book, which you can obtain at a discounted rate on the basis of this brochure. So feel free. So today's event has come together through the efforts of and support of several offices and individuals. And I'd like to take a minute to recognize them and acknowledge them. First, I want to extend our sincere thanks to the Phi Beta Kappa Society and their superb office staff in Washington, D.C. Today's speaker comes to us as a part of a terrific program that the Society sponsors called its Visiting Scholar Program. Since 1956, this program has been offering undergraduates at colleges and universities with Phi Beta Kappa chapters the opportunity to spend time with some of America's most distinguished scholars and artists. The purpose of the program is to contribute to the intellectual life of these campuses by making possible an exchange of ideas between the visiting scholars and the resident faculty and students, as well as members of the wider campus and surrounding community. Today's event is also the 15th annual Thomas M. Kerr Jr. Lecture on Law in American Society. I want to acknowledge our continuing gratitude to the Kerr family for allowing us to have Tom's name and legacy associated with this annual lecture. As you'll see from the biography of Professor Kerr in your program, his was a very full and impactful life, and particularly in areas of service. Service to country, service to community, service to his profession, and service to his university. This annual lecture reflects the expanded mission of the Carnegie Mellon pre-law program to not only serve its members who are considering law school, but also to serve as facilitator of civic engagement to the university and Pittsburgh communities in matters of law and justice that have broad relevance for us all. We think, as Tom would have wanted. And now to our special guest and today's speaker, David Rabban. David M. Rabban is the Dar Jamal Randall Hay Jamal and Robert Lee Jamal Regents Chair in Law and Distinguished Teaching Professor at the University of Texas School of Law. Professor Rabban served as counsel to the American Association of University Professors for several years before joining the Texas faculty in 1983. He later served as its general counsel and as chair of its Committee on Academic Freedom and Tenure. His teaching and research focus on free speech, academic freedom, higher education and the law, and American legal history. He was a fellow of the John Simon Guggenheim Foundation in 2016 and of the program in Law and Public Affairs at Princeton University in 2016-2017. Today, Professor Rabban will share his thoughts on academic freedom, its evolution from a professional norm on college and university campuses to a First Amendment right, and the current state of that right in the current political climate. Professor Rabban's talk will no doubt touch on many controversial subjects, such as restrictions on teaching designated topics and theories, regulation of hate speech or other speech deemed to be offensive and harmful to the learning environment, and the rights of students to free speech. It promises to be a most stimulating hour. With that, would you please welcome our 2025 Phi Beta Kappa Visiting Scholar and 15th Thomas M. Kerr Lecturer, Professor David Rabban.
Thank you, Dr. Devine. Thanks to the Phi Beta Kappa Society, and thanks to everyone who helped make this possible. I can hear myself fine. I assume you can and back. It seems very loud. Okay. So as Dr. Devine indicated, in my talk today, I'll review the justification for academic freedom that was first developed as a norm of the profession in the United States in the early 20th century. I'll then address the legal treatment of academic freedom as a First Amendment right. And I'll maintain that a distinctive First Amendment right of academic freedom should be differentiated from the general First Amendment right of free speech. And as Dr. Devine indicated during my talks, I'll touch on many current controversial topics, including recent threats to academic freedom from various state legislatures and from the Trump administration. So the 1915 Declaration of the American Association of University Professors, the AAUP, I will call it, contains what remains the most influential justification for academic freedom in the United States. The current regulations governing academic freedom in most American universities ultimately derive from the 1915 Declaration. And the 1915 Declaration tied its defense of academic freedom to its conception of the function of a professor. That is, the pursuit and dissemination of knowledge based on expertise gained through lengthy study. The Declaration stressed that professors cannot perform this societally valuable function if people without academic expertise are able to punish them for expressing their expert views. That's the central justification for academic freedom. Now, the 1915 Declaration recognized that if speech by professors does not meet academic standards, it is not the expert academic expression that contributes to the production and dissemination of knowledge, and therefore does not merit the protection of academic freedom. But the 1915 Declaration insisted that only other professors are competent to determine, at least in the first instance, whether academic speech meets academic standards. Involvement by others, it warned, would inevitably raise suspicion that the decision was based on inappropriate grounds, including grounds that might violate academic freedom. So peer review became part of the system of academic freedom in the United States. So with that brief introduction about the professional background, I'll now turn to the treatment of academic freedom as a First Amendment right in judicial decisions. In 1957, in a case called Sweezy versus New Hampshire, the United States Supreme Court, for the first time in 1957, identified academic freedom as a First Amendment right, contrasting it with political expression, another First Amendment right. In Keishian versus Board of Regents, 10 years later in 1967, the Supreme Court called academic freedom, quote unquote, a special concern of the First Amendment. Initially identified as a right of professors, judges subsequently extended the First Amendment right of academic freedom to universities as institutions. Now, as a preliminary matter, this is something many people don't realize and is very important, I feel. The First Amendment only applies to action by the state. So legislative and executive branches of government are state actors, as are public universities, but private universities are not state actors. First Amendment academic freedom, therefore, applies to legislative and executive actions that affect professors and universities, and to disputes between professors and universities at public universities. But it does not apply to disputes within private universities. The University of Pittsburgh is different from Carnegie Mellon. A professor at a private university can invoke First Amendment academic freedom to challenge legislation, but not to challenge administrators or trustees. And I'd be happy to expand on that in the discussion that will follow. I also want to emphasize that many private universities voluntarily accept for themselves the requirement that the First Amendment imposes on public universities. These private universities do not want to be perceived as giving less protection for free speech than public universities. For example, when I was a law student at Stanford University, a private institution, the university, in bringing dismissal charges for a professor for allegedly inciting to riot, instructed the committee hearing the charges to follow the First Amendment definition of incitement that applied to the University of California, Berkeley, across San Francisco Bay. So the legal distinction does not always matter in practice, depending on what private universities decide to do. Now, since the Keishian decision in 1967, many courts, hundreds, have repeated its identification of academic freedom as a quote-unquote special concern of the First Amendment. But very frustratingly, these decisions have not elaborated how academic freedom is special. Okay, it's special. How is it special? We don't know. Nor have the courts elaborated the relationship of academic freedom to general First Amendment rights of free speech. But courts have indicated through their decisions the scope of the First Amendment right of academic freedom, often yielding inconsistent results. Many cases have maintained that academic freedom protects the content of academic speech, and that academic freedom extends to pedagogical decisions by professors, protecting only those decisions that are made on academic grounds. Some decisions have limited academic freedom to the content of academic speech. So on this basis, a court rejected a challenge by professors to a state law, this was in Indiana, that made the use of aborted fetal tissue in research a felony. One of the professors who sued, challenging the constitutionality of this law, used mixed cell cultures derived from aborted fetal tissue to make major advances in the study of Alzheimer's disease, for example. Writing for the court in this case, Judge Easterbrook, a former professor at the University of Chicago. It's very interesting. A lot of the most important decisions dealing with academic freedom are written by judges who used to be professors, not surprisingly, but interesting to note. Judge Easterbrook being one, he maintained that the academic freedom claim in this case was a quote-unquote non-starter. Didn't simply reject it, it's a non-starter. Forget about it. Now, Easterbrook acknowledged that the use of fetal tissue in research could lead to speech in research itself, publications, and in the classroom, but he emphasized, and this is his language, that a desire to obtain an input into speech does not convert regulation of conduct into regulation of speech. And Easterbrook emphasized that the law challenged by these professors did not prevent them from writing or saying anything, or from citing research using aborted fetal tissues in states that allowed it. Okay. But other decisions have extended the First Amendment right of academic freedom beyond the content of academic speech. That's the core. Some cases have extended academic freedom beyond the content of speech. Some cases have applied academic freedom to preserve the confidentiality of a professor's research material. So decisions have limited attempts by litigants to discover the identity of members of the Irish Republican Army who feared violent retribution if their participation in an oral history project were disclosed. You can understand that concern. And also decisions have protected participants, the identity of participants in a medical study who are concerned about the privacy of their patient records. And beyond the core concerns of teaching and scholarship, some courts have extended the First Amendment right of academic freedom further to protect speech about university affairs, such as opposition to a university's foreign exchange program, and a proposal by a professor for a revised curriculum that would redress, in his opinion, the perceived imbalance between theoretical and practical courses in a school of mass communications. So, courts protected that speech as academic freedom. And a few cases, very few, have applied the First Amendment right of academic freedom to protect the political speech of professors outside the university, whether by Marxists or by conservatives. But judges overwhelmingly decided these cases through the free speech clause of the First Amendment, not through academic freedom, which, as I'll mention soon, I think is the correct way to go about deciding these cases. So, to summarize what I've said so far, case law has repeatedly identified academic freedom as a First Amendment right. That is clear. But the case law has reached inconsistent results about the extent of this right. So that may seem complicated enough, but I have some additional complications to add. I think, don't blame me, blame the courts. I'm just trying to convey what the state of the law is and isn't. So, many decisions do not even refer to academic freedom in circumstances when it clearly applies. So while academic freedom has been extensively recognized as a First Amendment right, it has also been extensively ignored. For example, in reviewing legislation that prohibited the teaching of evolution, or that required the teaching of quote-unquote creation science, the Supreme Court did not even address the academic freedom issues raised by the professors and even the lower courts. Instead, it invalidated this legislation, claiming that it constituted an unconstitutional establishment of religion prohibited by the Constitution. So these cases, it seems to me, indicate that the First Amendment right of academic freedom has not been deeply established because it is ignored in many cases. Even worse, in my opinion, other cases have applied general First Amendment law instead of the First Amendment law of academic freedom in ways that deny claims that should have been recognized under a First Amendment law of academic freedom. And I want to give some examples from the First Amendment law governing public employees, which is based on the principle that the state as employer has greater interest in regulating the speech of its own employees than the state as sovereign has interests in regulating the speech of citizens. So, to be protected by the First Amendment, speech by a public employee must be about a matter of quote unquote public concern. And many courts have concluded that academic speech is not about a matter of public concern and therefore is not protected by the First Amendment. For example, not a public concern but a private concern, not protected by the First Amendment, quote unquote abstract theorizing. That's pretty important to professors, right? And related to academic freedom, but not covered under the application of this First Amendment law governing public employees. Criticism of a university designed to make the university better. Private concern, not a public concern. Claims by professors that the university denied academic freedom while rejecting their tenure candidacies. It's a private concern between the professor and the university, not a matter of a public concern. Therefore, not protected by the First Amendment. Now, other cases have interpreted the term public concern more broadly to include this kind of academic speech, but others have not. In addition, speech by public employees under a Supreme Court decision about 20 years ago that I was myself involved in, and I can tell you more about it later if you're interested. In that case, the Supreme Court held that speech by public employees, quote unquote, pursuant to their official duties, is not protected by the First Amendment. So what are the official duties of professors? Well, I would say at the core, teaching and scholarship. So this holding is a great threat to First Amendment academic freedom. Now, importantly, I like to think based on a brief that I filed on behalf of the AAUP when I was its general counsel, right? The Supreme Court left open the possibility that this holding would not apply to the teaching and scholarship of professors. In the 20 years since this decision, quite a number of lower courts have held that there is an academic freedom exception to this general First Amendment law. But other courts have applied this law to professors without even considering the possibility of an exception, and have held that various speech by professors, including, criticism of curricular decisions made by their colleagues, are pursuant to official duties and therefore not protected by the First Amendment. So these and other problems with the general application of First Amendment law to the academic speech of professors, to my mind, underlines the importance of developing a distinctive theory of academic freedom as a First Amendment right, which would direct attention to the educational issues at stake in these cases. Even if a judge would reach the same result using general First Amendment law, I think it makes more sense to ask whether academic speech by professors meets academic standards than whether it is about a matter of public concern or made pursuant to official duties. I believe that a convincing theory of First Amendment academic freedom must differentiate academic freedom from general First Amendment rights while explaining why academic freedom still fits within the First Amendment. I mean, if academic freedom is the same thing as free speech, there's no need for a theory to protect it. But if academic freedom is different from free speech, you would have to explain why it fits within the First Amendment. And in my opinion, the societal value of the expert academic speech of professors, the basic justification for academic freedom in the AAUP's 1915 Declaration, also provides the basis both for differentiating academic freedom from general rights of free speech and for connecting academic freedom to the widely accepted First Amendment interest in the production and dissemination of knowledge. Academic freedom contributes to that First Amendment value. And I believe under this interpretation of academic freedom, right, it extends to a lot of the areas where courts have reached different conclusions. This definition should apply beyond the content of teaching and research, to pedagogical decisions, to protecting confidentiality, to protecting speech about educational issues facing the university. But this is controversial. This justification for academic freedom as contributing to the production and dissemination of knowledge does not extend to political expression by professors unrelated to their expertise. So under this analysis, the distinctive First Amendment right of academic freedom provides more protection to the academic speech of professors that meets the standards of peer review than the general First Amendment right of free speech protects expression by others. But if the expert speech of professors does not meet academic standards, professors may be disciplined even if other citizens would not be subject to punishment under general First Amendment rights. If professors speak outside their expertise, the First Amendment right of academic freedom, in my view, does not apply. But, right, professors should be protected in their general political expression by the same general First Amendment right of free speech that applies equally to everybody. So I hope that is clear. If not, or if people have questions about it, many people object to the lack of protection of academic freedom for general political expression. But I feel very strongly that the justification for academic freedom does not extend that far, though the protection for free speech does. Okay. As I mentioned at the beginning, in the late 1970s, courts began extending the First Amendment right of academic freedom to universities as institutions as well as to professors. And these cases often quoted language from Justice Frankfurter's concurring opinion, meaning agreeing with the others but on somewhat different grounds. Frankfurter, who was a law professor before he became a justice, quoted in his opinion in Sweezy from a South African statement that identified, and here's the quotation, the four essential freedoms of a university: to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study. And that language has been cited again and again and again in subsequent opinions as the meaning of academic freedom as an institutional right of universities. So I now want to turn to a proposal I have, and I elaborate in my book, that would be a major change in First Amendment law if accepted. My views on academic freedom as a First Amendment right of professors and universities would require like extensions or modifications of current law. What I'm now suggesting would be a major change in the current law. I believe that universities should be able to invoke their institutional right of academic freedom to regulate some offensive speech on campus that interferes with the learning environment, even if that offensive speech would be protected in the public sphere by the general First Amendment law of free speech. In the United States, as some of you may know, the law provides, under the First Amendment, substantially more protection for hate speech than in any other country in the world by far. And I've taught abroad, I've met professors from abroad, and speaking to people from abroad, they can't believe the extent to which American law protects hate speech. And we do it under the notion that we don't trust the government to determine what's hate speech and what's not, that giving the government that power undermines the protection for political speech in general. So there are reasons for extending it, but the extent of the protection is unique in the world. I want to point out that judicial decisions, particularly while invalidating campus speech codes, which regulate what can be said on campus, cases have applied general First Amendment law in analyzing these speech codes without modification in the university context. So I'm going to use some offensive language by quoting from cases. It's almost necessary to quote offensive language that may even be harmful in addressing these issues. But I think this language is important to understand the state of the law and my proposal. So in one case, in holding a campus speech code unconstitutional, the court observed that, quoting from the decision, right, the comment, "You're just a dumb black woman or homosexual," does not necessarily tend to incite violent reaction, even if it demeans the addressee and creates an intimidating, hostile, or demeaning environment. Only incitement to violent reaction, the court concluded, would be unprotected by the First Amendment. That is not an unusual decision, okay? Contrary to this decision and to the weight of current law, almost in every case, not every, but most cases in which campus speech codes have been challenged, courts have found them to be unconstitutional. I believe that the institutional academic freedom of a university should allow universities to discipline some offensive and harmful speech that would be protected in the public sphere. Gratuitous, offensive hate speech that could interfere with the learning environment. But I don't think that greater permission to regulate hate speech in the university context should extend to expression within the realm of academic discussion, right? If the hate speech relates to discussion of academic ideas, I think it needs to be protected, especially in the university. I recognize in some instances, exposure to certain ideas make it harder for some students to learn. But exposure to controversial ideas, it's part of the educational experience. And I would say, I'm glad there are a lot of students here, I would say, if you haven't been exposed to an idea that offends you during college, something's been missing from your educational experience. That's part of what learning involves. You shouldn't be gratuitously offensive, but some ideas that people study are offensive and could even interfere with the ability to learn. And I don't think universities should be able to regulate that kind of offensive speech. It's only the kind of speech that the court protected. I mean, it's just, if someone says, you're just a dumb black woman or homosexual using epithets, that's not related to discussion of ideas, and I think that should be subject to punishment. So just to give you an example, just based on an influential court case invalidating a university speech code, actually it was the first case in which the issue of university speech codes and their constitutionality was presented. A graduate student at the University of Michigan taught a course in comparative animal behavior. And he wanted to teach the theory in the field, and some of you may have studied this area, that males of various species, including Homo sapien, are better than females of various species at certain mental tasks related to spatial relationships. And some people, if this isn't offensive enough, go further and say, if you want to know why there are not more women in STEM fields, this provides at least part of the explanation. It's not all about discrimination. The Michigan Speech Code prohibited language that, quote unquote, victimized or stigmatized on the basis of race, sex, national origin, religion. And the graduate student, who was too scared to use his own name, so he sued under John Doe, said he thought that this theory stigmatizes and victimizes on the basis of sex. It stigmatizes and victimizes women. But he also said it's a theory that respectable academics hold in this field. And the judge said, I agree with you. The theory victimizes and stigmatizes, violates the university regulation, and that's why the university regulation is unconstitutional. I agree with that decision. Okay. I want to conclude by discussing recent threats to academic freedom from state legislatures and from the Trump administration. In recent years, as many of you know, I'm sure, state legislatures have passed laws that regulate the subjects and even the content taught in state universities. And these laws clearly implicate two of the four elements of academic freedom identified by Justice Frankfurter and quoted in hundreds of subsequent cases. What may be taught and how it shall be taught. The legislation interferes with those identified First Amendment rights. So I first want to say, which might surprise you from a strong advocate of academic freedom, as I perceive myself to be, maybe too strong in the opinion of some of you. In my opinion, some state legislation that affects the curriculum does not violate institutional academic freedom. And I want to take an example from my home state of Texas. Did you go to school in Texas too, as well as? Okay, so I don't know if you remember this, but in Texas, they may not have told you this in school, there has been a state law for a long time that every public university in the state of Texas must teach a course in American history. Does that interfere with the subjects taught at universities, with what may be taught? It sure does. But it seems to me a state legislature has a right to say to its state universities, you know, graduates ought to be familiar with American history. But I think recent bills passed in several states, including Texas, clearly violate the institutional academic freedom of public universities and the individual academic freedom of professors. And I want to highlight in this respect a highly publicized Florida law governing public universities in the state, which is frequently and tellingly referred to, some of you may have heard of this, as the quote-unquote Stop Woke Act, right? This is not a neutral intervention in state universities. So this act defines as unconstitutional discrimination instruction that, now quoting from the legislation, espouses, promotes, advances, inculcates, or compels a student to believe in 8 listed concepts. One concept is that an individual's, quote, moral character or status is determined by race, color, sex, or national origins, unquote. Other illegal concepts are that an individual, by virtue of these characteristics, should receive what the legislation calls, quote unquote, adverse treatment based on past actions by members of the same group, or to achieve diversity, equity, or inclusion. Can't do that. Similarly prohibited is the concept that, quote, such virtues as merit, excellence, hard work, fairness, neutrality, objectivity, and racial color blindness are racist or sexist or created to oppress. The law does provide that discussion is not prohibited if the instruction, quote, is given in an objective manner without endorsement of these concepts. So that's the law. I say this law is significantly more intrusive than the law declared unconstitutional in the Sweezy case, which first recognized academic freedom in the First Amendment right. In the Sweezy case, under state legislation, the state attorney general asked Mr. Sweezy, who was a guest lecturer in a course on economics at the University of New Hampshire, and who was a self-described Marxist economist. The state attorney general asked Sweezy whether he endorsed Marxism or the theory of dialectical materialism in his class. And Sweezy says, I'm not going to answer that question, and I don't have to because of my First Amendment rights. And the Supreme Court found in favor of Sweezy. That case, they were only asking about the contents, right? Which he said, I'm not going to tell you about. You don't have a right to know. It's protected by academic freedom. This Florida case, it's way beyond asking about what he's teaching. It's saying what you can and cannot teach. That's a much more significant intrusion than what has already been held to be prohibited by the First Amendment right of academic freedom. And I think it's interesting to review briefly the examples given by the judge who held this Florida law unconstitutional, of how it could interfere with instruction by the professors who challenged the law on First Amendment grounds. So here's the judge's examples. A law professor uses a casebook that, quote, explains how racism is embedded in the criminal justice system. Can't do that under this law. A professor of political science teaches courses in which she, quote, endorses critical race theory and assigns reading materials that advocate affirmative action, illegal under the law. And a professor of measurement and statistics, quote, encourages students to consider systemic discrimination when evaluating the effects of race in statistical models, illegal under the law. So the judge, based on his analysis and his examples, said that the law violated the First Amendment. He especially focused on the general First Amendment principle that the state cannot use viewpoint discrimination as the basis for determining what kind of speech is allowed or disallowed, which this law does. But he also referred to academic freedom. He said that under this law, now I'm quoting again, professors enjoy academic freedom so long as they express only those viewpoints of which the state approves. So using affirmative action as his example, the judge observed that under the law, a professor could discuss it as a fact, here, affirmative action exists, here's what it is, or condemn it as a failed policy. That's consistent with the law, but could not endorse its benefits. That would violate the law. So, consistent with this decision, with which I agree, while I think it is legitimate for state legislatures to mandate the teaching of American history as a subject in state universities, I think it would violate the First Amendment right of academic freedom if the state legislature either prevented or required professors to portray American history as an ever-growing progression of individual liberty, heroically, or as dominated by racism. Professors should be able to take positions on these issues as scholars, not as dictated by the state. And finally, I want to turn to these very recent threats by the Trump administration, threats on academic freedom. So you may have read about these instances at Columbia and Harvard, which I'm going to mention with different results at each university. So on March 7th, this year, 2025, the Trump administration canceled $400 million in federal funding to Columbia University without adhering to procedural requirements in law. And a week later, the Trump administration delivered an ultimatum to Columbia that within 1 week, it must provide a quote-unquote full plan to place an entire department under academic receivership for a minimum of 5 years as a precondition for formal negotiations about the university's continued financial relationship with the United States government. Columbia did not challenge this ultimatum, but a group of 18 scholars of constitutional law did from across the political spectrum, and I'm happy to say that I was one of them. And I want to emphasize, the scholars who signed this statement, some of them were very conservative, including the founder of the Federalist Society, a conservative group. So from conservative to very progressive professors, for example, the former legal director of the ACLU. So Columbia since has signed what it's called a settlement agreement with the government to receive money. And the agreement includes a provision stating that nothing in it, quote, shall be construed as giving the United States authority to dictate faculty hiring, university hiring, academic decisions, or the content of academic speech. Sounds good, right? It is good. Yet, several other provisions of the agreement would have violated the First Amendment right of academic freedom had they been imposed by the government, including provisions regulating the curriculum, regulating faculty appointments, and regulating student admissions. So this was, in my view, like a big cave-in by a major university to the government. But see now Harvard, since Columbia. Unlike Columbia, Harvard refused to accept the conditions imposed by the government to receive continued financial support, and sued the government, claiming that those conditions violated Columbia's First Amendment rights. And I want to quote from Harvard's complaint for relief, because it helpfully conveys what was at stake and what were the government demands. And this is my last reference to these attempted agreements. So here's the quotation from the Harvard complaint. On April 11, this is 2025, citing concerns of anti-Semitism and ideological capture, the government identified 10 conditions Harvard must satisfy to receive federal fundings already committed to by the government and relied on by Harvard, its researchers, and its affiliates. The government dictated that Harvard reform and restructure its governance to reduce the power of certain students, faculty, and administrators. It required that Harvard hired a third party to conduct an audit of the viewpoints of Harvard's student body, faculty, and staff. Then, based on the results of this university-wide audit, Harvard must hire a critical mass of new faculty and admit a critical mass of students to achieve viewpoint diversity in each department, field, or teaching unit to the government's satisfaction as determined in the government's sole discretion. And the government has demanded that Harvard terminate or reform its academic programs to the government's liking. All told, the trade-off put to Harvard and other universities is clear. Allow the government to micromanage your academic institution or jeopardize the institution's ability to pursue medical breakthroughs, scientific discoveries, and innovative solutions. And in a statement included in Harvard's complaint, the president of Harvard asserted, quote, "The university will not surrender its independence or relinquish its constitutional rights." And as many of you may know, the federal district court judge hearing this case recently found, in September, that that the administration had violated Harvard's First Amendment rights. Although, frustratingly to me, she did not discuss the connection between general First Amendment rights and academic freedom. Both issues were raised. And now, finally, more recently, some of you may have heard about this proposed compact for academic excellence in higher education. You're aware of that? I'm nodding. Just about 2 weeks ago. And it proposed this compact to 9 universities, including my own. And this compact contains similar provisions that violate First Amendment academic freedom rights of institutions. It turns out, this is very significant, I believe, as of yesterday, very quick this happened, 8 of the 9 universities that received this compact declined to sign it, citing concerns about academic freedom. I'm sad to say my own university is the only one who has not refused to sign it, but they haven't agreed to sign it either. and they are very aware of concerns about it, including from another statement signed by 6 professors who write about academic freedom across the political spectrum, including myself. So we'll see what happens. So just in conclusion, I want to reiterate 3 of the points I've tried to make thus far. First, courts have clearly recognized academic freedom as a First Amendment right of professors and students. That's the law. But second, and frustratingly, the meaning of this right and its relationship to general First Amendment rights remain unclear. And the third and final summary point I want to make is that these recent threats to academic freedom by state legislation and demands to universities from the Trump administration have been unprecedented. Right? The McCarthy era was bad. There was lots of pressure to fire professors who had been members of the Communist Party, were members of the Communist Party, other left-leaning professors. But the focus then was on potential subversive activities. Many professors were fired. That really hasn't happened yet today. But the difference today, and why I think it's much more threatening, is that the threat to academic freedom is not focused on a subset of professors based on their political ideas. It's focused on the very enterprise of the university and the right of the university to determine its educational functions, threatening universities as well as professors who work in them. So I'll stop with that and look forward to any questions, comments you might have. We have another half hour.
Yes.
Do you want to recognize people, or should I just?
I'll leave it up to you.
I was going to leave it up to you. I guess I'm standing. I can look out, so I'll recognize people if there. I hope there are some questions or comments, including disagreement, because that's what academic freedom is all about, right? Yes, sir.
I may have misunderstood your modest proposal for reforming, academic freedom of universities, but it sounds like you are advocating that the universities take on essentially the same role that you are railing against that the administration is doing. In other words, the university is going to make the decision about what student conduct is detrimental to education and interfering in education.
Right.
And why is that an improvement over the current situation?
That is the current situation. Who does make these decisions today?
Well, then
Who determines?
So I misinterpreted your proposal. Can you tell me what your proposal is then?
It's not, my proposal or my interpretation is that universities, by the way, before my proposal, the state of the law is, I think that's important to make clear, that, this is since the 1970s, universities as well as professors have a First Amendment right of academic freedom. That's the law. Okay. And I think that's good and reflects what universities do and have done. The danger is that the state intrudes on the educational decisions of universities. And that's what Justice Frankfurter emphasized in his concurrence in Sweezy. He emphasized the importance of free universities in a free society. And then he said a major worry, the thing we need to watch out for, is government intervention in the intellectual life of universities. That's almost a word-for-word quotation, probably close paraphrase. I agree with that. Now, a big issue comes up, and that may be kind of the thought behind your question too, is who makes these decisions on behalf of the university? That's a big issue and hasn't been addressed much in law. I have a lot about it in my book. I only had an hour to talk. There's a lot you can't cover. I'm glad you asked. There's a document, some of you may be familiar with it. It's called the 1966 Statement on Government. It was jointly signed by the AAUP, endorsed by the AAUP, the American Council of Education, which represents universities in their institutional capacity, and the Association of Governing Boards of Colleges and Universities. So different groups within the university agreed with this statement of government, which emphasized shared authority, but also identified that different groups within the university had primary authority depending on what the decision is. So in my view, and in the view of the statement, most academic decisions should be made in the first instance by faculty, curriculum, hiring, etc. But there are overall policies, like whether to accept this, pact or not, whether to start a new program in a particular area. I think these are educational decisions. Whether a department needs some rejuvenation and pumping up with different kinds of hires. There's a role for a university administration that's recognized by that statement, even though normally the primary role should be professors. I think that makes a lot of sense, and I hope that the development of the First Amendment law of institutional academic freedom would refer to those considerations in making decisions. Now, there are conflicts between institutional academic freedom and the academic freedom of professors, and those need to be addressed and resolved. But the notion that universities as institutions have the role in making academic decisions, and it's better to have those decisions made within universities than by people outside universities who are unfamiliar with educational issues and may be likely to be intervening for inappropriate reasons. That's a good thing, I think. Would you disagree with that?
I'll let others.
Okay. Yes.
Yeah, so I have a question about the pact. And if the University of Texas was to sign this pact, I imagine it would be forced by the government. Context, I'm a Texas A&M grad, and the government basically just pushed out our university president. So in that case, is the legal battle, the possible litigation different? Because it is the state government most likely kind of forcing a state school to do actions that reduce the rights of professors there. Who would the plaintiff be?
Well, the plaintiffs would be the professors of the universities if they have the, obviously, courage to challenge the state. But it's a harder case for a state university to make against the state legislature than for a private university, even though, since it's the state acting, right, it affects private universities as well. I think judges feel, understandably, that kind of plurality in educational institutions is a good thing for education. It's good to have private institutions as well as public ones. And I think judges would more easily strike down state restrictions on the educational decisions of private universities than of public ones. But I believe public universities have strong First Amendment claims with respect to the pact, as Florida, won its decision challenging that anti-woke legislation. Yes, way in back.
My question is about the protection of speech off campus.
Yeah.
I don't know, I missed the beginning of your talk, so I don't know if you mentioned that the origin of free speech debate in the United States is usually traced to a case at Stanford where a professor was fired precisely for political speech made off campus.
You're not thinking of the Bruce Franklin case, are you?
This would be back in the
Late 60s, early 70s. Oh, yes, that's the Roth case. Yeah, I know that case, yes. I can elaborate that.
It seems to me that, if I'm understanding your talk correctly, that basically professors at private universities, political speech off campus is not protected by academic freedom at all.
By the way, I go further and say political expression unrelated to expertise by professors at public universities should not be protected by academic freedom. It doesn't make sense to apply the concept of academic freedom to speech unrelated to expertise, but it should be protected for the person at the public university by general rights of free speech. Academic freedom and free speech are not the same.
So, right, but so the law protects the professor from being thrown into jail for expressing a controversial political position, but not from being fired.
No. Well, yes to the first part, can't be thrown in jail. I believe, and some university presidents have said this, that the university, others deny it and act on the basis of the denial, but many university presidents have said over the decades, the political expression of professors outside their expertise and off campus is outside our jurisdiction. Our jurisdiction is the educational functions of the university and whether the professor is meeting the academic standards. So there's a very interesting case, I think, you'll see if you agree, involving Harvard again, and this is during World War I. I think it addresses your question. There was I believe he was a professor of psychology at Harvard. I think his name was Hugo Münsterberg, something like that, from a German-American family. And he had written essays, right, and given speeches, I believe, off campus, opposing American intervention in World War I. At a time when that was extremely unpopular, and many people were being sent to jail for doing that. A wealthy donor of Harvard had pledged $10 million to Harvard. That was money in 1917. Arguably, it's money today, right? And the donor said to the president of Harvard, who I believe was President Lowell at the time, if you don't fire this man, I'm not giving the bequest. And Lowell wrote back, and the Harvard Board of Overseers backed him. I mean, it helps to be a wealthy institution, but it also helps to have some principles in mind. Columbia and Harvard are both wealthy, to take the recent examples. Lowell said, and he put this in his annual report, if Harvard starts disciplining people based on their off-campus general political expression, it will be considered implicitly to have approved all extramural political expression it hasn't punished. Okay? This isn't Harvard's business. If Professor Münsterberg violated a law, he should be prosecuted by the legal authorities. Harvard should be concerned about whether he is meeting his academic obligations. And it would be inconsistent with the function of Harvard as an educational institution to fire him because people disagree with his political views, end of story. So I do think that is an example that speaks to your question.
Absolutely relevant. You mentioned that individual professors hadn't been affected so much lately, but I've heard, at least anecdotally, a number of cases related to the Kirk killing.
Yes,
People were fired.
including, was A&M one of them? There was a school in Texas who was, yes, so that's happening now. It is happening now. Yes.
As I understand it, the Harvard case is not ended. I mean, it's going to
Correct.
continue beyond. So what I wanted to ask you is, despite the fact that we're having arguments over First Amendment rights and academic freedom, the really existential threat and the new point of leverage today, de facto, is research money.
Yes.
And that has not been the case before. So what makes the compact most threatening to universities is that under the terms of the compact, if a university were to sign it, all research funds would have to be returned to the federal government if the federal government determined that they were going against what they had agreed to, and you have to go back to donors and return that money. So
I'm not sure they go that far, but maybe.
I could be
Anyways,
wrong,
pretty, not just return, but, and you're not going to get any more either, by the way.
So isn't that really, even if we win on academic freedom and First Amendment rights, isn't the truly existential threat and the thing that is unprecedented the use of the leverage of the financial support?
Yes, yes, and that's why I say the threat is greater today than during the McCarthy era. But the Harvard decision, right, prohibits the government from withholding funds based on the viewpoints of people within universities or based on the educational decisions made by universities. So the decision covers that issue. Whether the Trump administration will follow that decision, whether the higher courts will agree, who knows? I also want to say, I think this is very important to keep in mind. Your question addresses the issue. I think these threats from the administration are extremely dangerous and unprecedented. But, it's distressing me that universities don't have more backbone in resisting, such as Columbia. But, you know, if Columbia lost $800 million of federal funding a year, it would destroy the careers of hundreds of faculty in STEM fields. It would destroy the reputation of Columbia University as a major research university in the United States. There's a lot of pressure to make accommodations, and I think many of these schools are trying to. It somewhat bothers me when academic freedom purists condemn universities for even negotiating with the Trump administration. I mean, there is a lot at stake, including a lot of important educational functions at stake. So to me, interference with the curriculum, what professors can and cannot say, that should be the red line. And if the money is lost, you know, too bad. But I certainly understand the pressures on universities to cave. I also think that combined resistance, like these 8 schools that have rejected the compact, that puts pressure back on the government. And I think like solidarity among universities, among professors and administrators against this, you know, sometimes when you push back, people stop. And especially when conservative professors are involved in the pushback, which some are, in my view, heroically. Yes, sir.
David, first, thank you for being here.
Well, thank you for inviting me, and thank you for coming.
For presenting these provocative and interesting ideas. There are multiple things we could touch on, but I don't want to monopolize the next 20 minutes of discussion. Let me just touch on a few items, though. Let me touch specifically on Harvard, where I went to law school and where we've been involved with alumni activities. I think you should point out to people that the federal district court judge in this case is Allison Burroughs, right?
Yes.
She's the same judge who made those decisions in the affirmative action cases.
Yes.
And all of which were thrown out by the U.S. Supreme Court.
Correct.
So there's a fair chance, you know, the First Circuit may affirm many of her decisions, as they did in the affirmative action cases. There's also a fair chance the U.S. Supreme Court will throw out her conclusions in this case. So when you say, oh look, a federal judge has ruled this, well, it's like federal judges have ruled on a number of matters in the last 9 months, ultimately need to be overturned by the U.S. Supreme Court. So let's put this in context. Allison Burroughs has been particularly friendly to Harvard's positions on a number of things.
Even though I think they rejected her as a law student. I think I read that somewhere. Or an undergraduate, maybe.
She has family members who are
Uh-huh.
Harvard. So So she's a Harvard-friendly judge.
Right.
And I think the fact that she made these decisions, whether one agrees with them or disagrees with them, if you put this in context, and the other really important case she had just decided by the Supreme Court in 2023, where obviously ultimately the Supreme Court disagreed with most of her conclusions. So on Harvard, it's not as if Harvard is this incredibly principled First Amendment university.
Well, it was in this case. It was in this case.
Well, I'd say, no. Let me
Okay.
put this in context, then you can
Yeah, go ahead.
disagree. And,
Right, sorry.
This is intended to be, just as you've thrown out these provocative ideas, which I think are very interesting, let me throw some out as well, and then
Right.
we can discuss them. Harvard's, on the fire sort of evaluation last year,
Right.
Harvard came in dead last of over 200 universities. Our friends who were Jewish students there, our friends who were conservative or libertarian students, there's very little freedom of expression at Harvard. People who are Republicans don't even let their friends know they're Republicans on that campus.
Right.
Okay, Jewish students felt terribly intimidated over the last 2 years, both
Right.
at the law school, students I've talked to, and undergraduates.
Right.
Harvard did very, very little, if anything, to protect them. Okay, they basically let certain political groups run roughshod, even though certain other groups
Right.
felt significantly intimidated by this. Okay, Harvard, they didn't stand up to the government. They were one of the first universities to fire the president. So their president lasted about 6 months. Once there was a political controversy over her testimony and thing, and once there were questions about plagiarism in her academic work. So they're one of the first universities to cave. Okay, to have the president resign under pressure, I mean, that's not a sign of great moral strength. Now, with respect to this thing, where they basically have sued, I think, having handled many, many regulatory matters in my life, I think they've totally mishandled this. Because what happens is, what the federal government has, you have 3 different classes of cases, right? You have research money where the work has been performed. And almost certainly Harvard and other universities will get paid that money, even if the Trump administration tries to withhold it. You have current contracts where, under these federal contracts, there are lots and lots of loopholes and force majeure clauses. So because the federal government may or may not be able to cancel those. But with respect to future monies, nothing can require the federal government to give these contracts, many of which are under 10% of the applications in front of NIH or in front of the National Science Foundation are granted. Nothing requires the federal government to give those monies in the future to any particular university. So Harvard's leverage is going to be limited, and ultimately I think they will settle. By the time the federal government looks through every single contract, half of Alston and Cambridge is owned by Harvard. When you look at the differentiation between the nonprofit and the for-profit activities, if these things are really scrutinized and audited, they will find things that are problematic. I can almost promise you that. Okay, and Harvard ultimately will have very, very little leverage. So it's not as if this is a strongly principled university that's taking a courageous stand against the federal government where other universities aren't. This is a university that's had very, very little moral courage, and has had tremendous fallacies in its morality and in its integrity for years. And now sort of someone's calling them on it, and my prediction is ultimately that they'll settle. And I think if they do take it to the court system, I think at the Supreme Court level, they will lose some key things here. And I think Alice Burrow's decision ultimately, just as in the affirmative action case, where there's clearly discrimination in my view against Asian American and white students, I think it's seriously problematic. I think if Harvard proceeds, they will ultimately lose on some key things, like future contracts. So we'll see what happens, but as I say, I wouldn't hold Harvard up as some moral exum or any of this. But I throw those out as ideas.
Okay.
I fully recognize you may disagree, it'd be
So-
interesting hearing your counter-arguments.
So I don't defend the morality of decisions made by Harvard University over the years. So I do think, I may be wrong about it, that the new President Gerber has even recognized some of the problems that you've identified before the Trump administration did anything. So some of this stuff is kind of apart from the current controversy over funding. I was commenting, and comment now again, on Harvard's reaction to the pressure from the Trump administration to sign an agreement enabling the Trump administration to make basic educational decisions. On that issue and that issue alone, I think Harvard took a courageous, even moral stand, and Columbia did not. On other issues, maybe not, maybe not. On what happened to the last president, that's complicated. I'm not going to get into that here. I think it's a little on the side. She didn't do a very good job, I feel, before Congress, and there might have been reasons to let her go apart from discrimination.
There were plagiarism.
And even was she performing effectively before Congress? Okay. Yes, yes. So, by the way, Judge Burroughs is not the only judge in the United States who has rejected arguments by the Trump administration or by analogous legislation. There's this judge in Florida. I don't know where he went to law school. I don't think he went to Harvard. And there are other decisions that have overturned university decisions to fire faculty for their free speech. I don't think, she's not a unicorn, if that's,
But many of those decisions, though, at the district court level have been overturned on a whole bunch of issues.
on different issues, right. I just had a,
The Supreme Court have upheld, but a majority of important ones, the Supreme Court.
it's true. So what will the Supreme Court do in this case? I don't know. I'm not saying I'm optimistic that the Supreme Court will follow the existing law. I am trying to say what I think the existing law is. They may just take a different approach. Just on Supreme Court, gazing. I'm not an expert in this and don't find it particularly interesting. There are a lot of people who focus a lot on what a particular judge is going to do in a particular case, which is important for a litigant, of course. But as a scholar, it's more psychology almost than law. Here's my intuition, and it may be over-optimistic. I just want to grant your point. The Supreme Court may not uphold Judge Burroughs' opinion. There's substantial chance that it won't. If it doesn't, I think they're changing the law. But they've changed the law in a lot of areas recently, including affirmative action, as you were referring to, including right to abortion, etc. Here's my optimistic intuition, but I don't feel very confident about it. I think their conservative justices, unlike in the affirmative action case or in a lot of these other cases, independence of administrative agencies, every context is somewhat unique. And I think Chief Justice Roberts and Justice Comey Barrett understand the value of American higher education. I think they might respect the role of universities in making educational decisions, the role of faculty in determining who meets academic standards and who doesn't. Comey Barrett was a law professor, and Roberts, he attended Harvard College and Law School, and I don't think he's kind of as bitter at the American educational system as some of the other conservative justices. So I think it is, let me put it, conceivable, not likely, conceivable, that 5 justices, the 3 liberals and Roberts and Barrett, might vote to uphold the basic long-standing structure of judicial deference to the educational decisions of universities. I think that's a possibility. I even think it may be more likely than not, but I have no confidence in that prediction. So I'm not sure how much I'm disagreeing with you.
Right, so, I'll let others
Yeah.
answer.
We should probably wrap it up, Dave.
Okay. Great. Well, thank you.